Hey everyone, welcome back to the channel that provides you exciting landmark legal cases from around the world. Imagine a political figure fleeing their country, seeking asylum in a foreign embassy, and that country demanding he be handed over immediately. But what happens when international law gets in the way? Welcome to one of the most fascinating legal battles in international history, Colombia v. Peru, also known as the Asylum Case. This case dates back to 1948 in South America, a time of intense political unrest. After a failed military rebellion in Peru, a Peruvian politician named Victor Raúl Haya de la Torre, who led the American Popular Revolutionary Alliance or APRA, sought asylum in the Colombian embassy in Lima. Colombia granted him asylum, claiming it had the right to do so based on regional custom and inter-American agreements, like the Havana Convention of 1928. Peru, however, refused to grant safe passage out of the country, effectively trapping Haya de la Torre inside the embassy. So, Colombia took the matter to the International Court of Justice in 1949, arguing that Peru was violating international law by not recognizing Colombia's right to grant asylum and by refusing to let Haya leave safely. At the heart of the case were two major legal questions. Did Colombia have the unilateral right to qualify Haya de la Torre as a political refugee under international law? And was Peru obliged to grant safe passage for the asylum seeker to leave the country? Colombia leaned heavily on regional customs and agreements, like the Havana Convention and practices common among Latin American countries, to argue that it had the right to grant asylum and demand safe conduct for the refugee. Peru, on the other hand, pushed back, arguing that international law, and even the agreements Colombia cited, did not allow one state to unilaterally impose such a decision on another. The ICJ sided with Peru, delivering a judgment in 1950 that said, Colombia could not unilaterally determine whether someone was entitled to political asylum in a way that would bind Peru. There was no binding custom that gave Colombia the legal right to demand safe passage in this context. And importantly, regional agreements like the Havana Convention didn't grant automatic or enforceable rights unless both countries agreed on the interpretation and application. So essentially, Colombia lost the case. This case is still widely studied today because it highlights some super important issues in international law, the limits of regional custom versus universal international law, the rights of states to grant asylum and how those rights intersect with the sovereignty of other states, and the idea that just because a practice is common doesn't mean it's legally binding. It also set a precedent that embassies can offer protection, but they can't force the host country to accept that protection as legally binding without an agreement in place. If you found this breakdown helpful, and you love learning how international law actually works in the real world, hit that like button, and subscribe for more quick legal explainers. Got a topic you want covered? Drop it in the comments. I read every one. Catch you in the next one.